So when we came to write the fourth edition of Fenley and Leach, Tom, I think you suggested that we might change the title from Solicitors' Negligence and Liabilities to simply The Law of Solicitors' Liabilities. Why was that?
Tom, I hope I wasn't being too presumptuous in making that suggestion, but it did strike me that the book had really, over time, adapted to a landscape where solicitors become involved in litigation in fields which are often quite far removed from the classic territory of your professional negligence claim. So there are now, I think, chapters on disciplinary proceedings against solicitors, on the regulatory environment in which solicitors act, professional indemnity insurance, and my own chapter, solicitors' duties of confidentiality. And certainly what I've discovered in researching that chapter is that there really is a very sophisticated body of law on the interrelationship between confidentiality and solicitors.
Well, that's very interesting. I mean, there are often a number of cases where former clients seek injunctions against their solicitors if they start acting for another solicitor and a retainer, which might involve the misuse of former clients' confidential information. Isn't that right?
Absolutely, a real growth area. You'll remember that in that kind of situation, the classic case of Bolkaya and KPMG decided that where a solicitor acts in a retainer which is adverse to the interests of his or her former client, then the burden is placed by the law very firmly on the solicitor to show that there is no risk of misuse of the former client's confidential information. And unless the solicitor can discharge that burden, then they will generally be prevented from acting for the new client. And of course, there have been very, very large numbers of cases where solicitors have found themselves in that particular firing line. But interestingly, the law has extended in some interesting and potentially expansive ways. Of course, solicitors may find themselves now owing duties of confidentiality not just to their former clients, but to parties on the other side of litigation in which they've acted, parties to whom they are otherwise in an adversarial position. A particular issue can arise where solicitors act for different litigants against the same defendant. So what happens when the solicitor acting for client A, let's call her, attends a mediation with a defendant and the case is settled on confidential terms? The solicitor will usually have signed a mediation agreement in which they agree to preserve the confidentiality of the process. And you might find that the solicitor obtains during the process of that mediation a very strong insight into the defendant's negotiation tactics, its perceived weaknesses and strengths, and its bottom line. What happens then if the solicitor then is instructed to act for client B against the very same defendant in relation to similar proceedings? Can the defendant object to the solicitor's acting on the basis that the solicitor will inevitably bring to bear in the new retainer for client B its knowledge obtained during the confidential setting of a mediation as to the defendant's general approach to settlement negotiations and as to its, frankly, its bottom line?
Well, can you really get an injunction in those circumstances? I seem to remember that there is a New Zealand case about this, which you've discussed.
Certainly there was. About 20 years ago, the New Zealand Court of Appeal decided a case called Carter Hill and Sunnex Logging. And in that case, a defendant actually succeeded in obtaining an injunction against the claimant's solicitors on the basis that those solicitors had previously acted for another client in a similar type of case who'd sued the same defendant, and that case had settled at mediation. And what the New Zealand court decided was that the Bolkaya and KPMG test was applied so that the burden was placed very firmly on the solicitor of showing, if they could, that there was no risk of misuse of the defendant's confidential information obtained during the mediation process. And this was even though the solicitor had, of course, never acted at all for the person seeking an injunction. They had always been in an adversarial relationship with the defendant.
Well, that seems like a pretty harsh result to me. And has that case been applied in England? How's it fared here?
Well, the English courts, I think it's right to say, have accepted in principle that a solicitor who has learnt confidential information during the course of a mediation or a confidential without prejudice discussion may be liable to be prevented from acting against the same adversary in later proceedings. Most recently, there was a case decided by the Court of Appeal last year called Glencairn against Product Specialities. And what happened there was that a company, I'll call them X, had sued a defendant Y in an intellectual property dispute. And a settlement was reached after a confidential mediation process. Company X then sued a different defendant, Z, I'll call them, in relation to a very similar claim. And strange enough, the claim was about the shape of whiskey glasses, of all things. Z, in defending the claim brought by Company X, retained the same solicitors who had acted for previous defendant Y. Now, here, the solicitors actually set up an information barrier so that the team which had acted, that was acting for defendant Z, the new defendant, was wholly different from the team that had previously acted for defendant Y, fighting off the same sort of proceedings against the claimant X. Nonetheless, the claimant sought to injunct the solicitors from acting for defendant Z. Now, the critical point on the claim was the incidence of the burden of proof. Should it be for the solicitors to establish that there was no risk of a disclosure of the claimant's confidential information? Or conversely, should the burden of proof remain on the claimant in showing a sufficient risk of misuse of the claimant's confidential information by the solicitors to warrant the court's intervention? The first test would be the Bolkaya test. The second test would be a rather more watered down version. The court decided the latter to the benefit, of course, of the solicitors. Nonetheless, it's right to say that the court still accepted that in principle, a claimant may be entitled to an injunction preventing a solicitor from acting because it might have acquired the claimant's confidential information during a confidential settlement process, whether it's a mediation or without prejudice discussion. And that can be, I think it's fair to say, a pretty serious inroad into a client's right to the representation of his or her choice.
Well, that's very interesting. I can see that in a case where you've got intellectual property, protection of the confidential information could be really important. But have there been other examples in English courts, litigants, seeking to prevent the other side from instructing solicitors of their choice?
There have been in all sorts of scenarios. Sometimes it's because a privileged document or set of documents has been accidentally disclosed by one side to the other side in litigation. And the other side's solicitors have then gone on to read that confidential privileged document, possibly knowing that it was privileged. In that kind of situation, the court has on occasion intervened not just to prevent solicitors from making use of the privileged information, but from acting at all. In a recent case called Schlossberg and Avonwick Holdings, a very well-known firm of solicitors was actually prevented from acting against a particular person because they had received a huge batch of privileged documents belonging to that person after he'd been made bankrupt. So that's an example of a solicitor's firm being prevented from acting. And another example, a few years ago, was a case called B Sky B and Virgin Media Communications. And in that case, BSB disclosed documents pursuant to the normal disclosure process in high court proceedings brought by Virgin. And some of those documents were so commercially sensitive that a confidentiality club was created, whereby the documents couldn't even be shown to the client, but only looked at by Virgin's solicitors. Now, what then happened was that Virgin brought proceedings against BSB in an entirely different venue in the Competition Appeal Tribunal, but using the same firm of solicitors that was acting in the High Court proceedings. Now, what BSB then did was to try to prevent that same firm of solicitors from acting in the CAT proceedings on the basis that they would not be able to put out of their minds the documents that have been disclosed in the High Court proceedings and which might influence their conduct of the CAT proceedings. The point being, of course, that when documents are disclosed in normal court proceedings, there is an implied undertaking, as it's traditionally known, not to make use of those proceedings, those documents in other contexts, unless the court gives permission or in other narrow scenarios. Now, I'm pleased to say that BSB lost that application. The court expressed itself very concerned to preserve the principle that a client should, so far as possible, be able to instruct solicitors of its own choice. But I think those two examples, those two cases, the Schlossberg case and the Virgin and BSB case, provide kind of vivid examples of the conflicting principles that are at work in this area. On the one hand, the desire of the court to ensure that a client, a litigant, has the representation of its own choice. On the other hand, the conflicting principle that where a solicitor or a firm of solicitors has confidential information within its kind of collective knowledge obtained from the other side, there should be some form of regime to prevent that confidential information being potentially misused to the disadvantage of the adversary to the litigation. I think where we can make a landing, Tom, on this is that the traditional sense of solicitors are involved in litigation themselves simply as being people being sued for negligence. We're a very long way removed from that, and solicitors now find themselves being sued or in litigation themselves in a much wider set of scenarios.